these courts.
More than 6 hours of court judgment and several years of standing trial on terrorism allegations, leader of the proscribed indigenous people of Biafra, Nnamdi Kanu, was today sentenced to life imprisonment for terrorism. Today on Beyond the Headlines, we'll bring you an analysis of one of the most high-profile and dramatic cases in recent Nigerian legal history, the terrorism trial of Nnamdi Kanu, who is leader of IPOB. I am Abosedi Adeniraduremi, standing in for Nifemi Oguntoye. The courtroom erupted this morning as Nnamdi Kanu, visibly agitated, refused to comply with court orders demanding to file his final written address and challenging the authority of Justice James Omotosho. The tension escalated into a physical scuffle with security personnel, forcing the court to proceed in Nnamdi Kanu's absence. In a landmark ruling, Justice Omotosho found Mr. Kanu guilty on all 7 counts, ranging from terrorism to incitement to violence, membership of a proscribed organization to acts purportedly justified by claims of self-determination. The court stressed that violent means cannot be used to pursue political rights and highlighted the constitutional requirement for any such pursuit to go through proper legal channels. Now, Justice James Omotosho said he sentenced Mr. Kanu to life imprisonment on count 1, 4, 5, and 6 instead of a death sentence. He also sentenced the IPOB leader to 20 years imprisonment on count 3 and 5 years imprisonment on count 7, with no option of fine. He said the sentence shall run concurrently. Now, Mr. Kanu's trial has been one of Nigeria's most talked about legal battles in recent years. He was first arrested in 2015 and charged with treasonable felony and terrorism, but the case has since taken numerous turns.
Our Lord himself is merciful. No matter what we do, he is a merciful God. It is on that note that the court will follow this above admonition of Jesus Christ in the above passage and show mercy to the convicts. In addition, the death penalty globally is now being frowned upon by the international community. Consequently, and in the interest of justice, I hereby sentence the convicts to life imprisonment for the said counts 1, 4, 5, and 6 instead of death sentence. Life is sacred to God. With respect to count 3, he is hereby sentenced to 20 years imprisonment without no option or fine. For count 7, he is sentenced to 5 years imprisonment without no option or fine. To extend the mercy, I hereby order that the sentence shall run concurrently.
Well, joining me to unpack the legal, constitutional, and political dimensions of this verdict would have 2 seasoned legal minds, a former Attorney General and Commissioner for Justice in Kwara State, Salman Jawondo, SAN, and an experienced lawyer, Liberus Shoma. But before that, we'll bring in our correspondent, Celestine Area, who has over the years covered this case and today was in the courtroom bringing us all of the details. Celestine, since 2015, here we are today, judgment, finally being delivered. Talk to us more about what happened in the court and the significance of this move.
Okay, well, today proceedings started with a little bit of drama where Mr. Kanu had insisted that the judgment should not be delivered and he cannot be sentenced, that Justice Omotosho was not in his right to do so. We saw how he was visibly angry It took the officials of the DSS in court trying to calm him down. The judge pleaded with him to calm down, that he should listen, that there's a process to these proceedings and decorum should be followed. But he was angry and insisted that he cannot be convicted on sentence under and on no law. So he was not ready to calm down. He was still visibly angry. The court had to ask that he be taken out of the court. And we could see that when he left the court, he was still speaking, he was still very angry. So when he left, the prosecuting counsel had moved that he invoked a session from the ACJ that allowed the court to continue proceedings in the absence of the defendant, and also the court to enter a sentence in his absence as well, and which the court did, and the court gave its verdicts, convicted the defendant on all the charges, and also in the absence of the defendant, also sentenced him, but asked his consultants, who were his former lawyers that Mr. Kanu sacked and made his consultants, to convey the sentence to him. Before the sentence was delivered, the judge asked for locutus, which is like an avenue for the defendant's lawyer or the defendant himself to plead for leniency or mercy, as the case may be. Since Mr. Kanu was not physically present in court at that time, the court asked his lawyer, his former lawyer, Alo Ejimako, to do that for him. But Mr. Ejimako said that he didn't have the right for Mr. Kanu to do so. Instead, he passed it on to a House of Representative member representing the constituency Mr. Kanu came from. And he pled for leniency and mercy, and the court to temper justice with mercy, which made Justice Omotosho to commute the death sentence, which he ought to have given, to life imprisonment. And considering the fact that we have about 3,927 inmates awaiting death sentences, and knowing for a fact that governments these days do not really want to sign the death warrants. And also, these were the reasons considered by the judge. Had he said mercy will play here, as everybody is entitled to mercy. And he also made reference to a chapter in the Holy Bible. So this was just summary of what happened in court today.
All right, Celestina, thank you very much for bringing us up to speed on that. Thank you. Well, let's now get more legal perspective to this development. And joining me is a former Attorney General of Kwara State, Salman Jawondo Essien. Mr. Jawondo, Nnamdi Kanu has been sentenced to life imprisonment. And Justice Omotosho did mention that this was instead of a death sentence on count 1, 4, 5, and 6. How significant is the court's reliance on Kanu's own broadcasts and public statements on establishing intent? Mr. Jawondo, sir.
Judge must have basis. Yes, thank you for having me. Good evening.
Good evening, sir. You may please respond to the question.
Hello?
I can hear you, Mr. Jawondo. Kindly respond to the question, sir.
Okay. So I was saying that the judge must have considered the evidence before him, before relying on the broadcast made by Kanu. And don't forget, he made several broadcasts of which is inconsistent with peace and stability of the country. So by relying on those broadcasts, and don't forget also that Nnamdi Kanu did not give evidence to deny those broadcasts. He did not call any witness. So those facts are deemed established. In other words, those broadcasts are deemed to have been made by him, since there's no counter evidence. So the judge was right and on a very firm ground in relying on those broadcasts to convict him.
All right. I will know that after that judgment was delivered, our correspondent was speaking with his consultants, now his former lawyers. And, Alo Ejimako did mention that this is the first time that, someone would be sentenced over word of mouth alone. Liberal Shoma is with us now. Mr. Shoma, if we look at the events that preceded the judgment, how unusual is it for a defendant to be removed from court for unruly behavior? And what does this tell about the limit of courtroom decorum in high-profile trials?
First and foremost, even though, like the judge rightly noted, even though the Constitution states clearly that an accused must be present throughout his trial, but also there are exceptions that except in cases when the accused, his presence in court will be unruly and will pose danger to the court. And so rightly, the judge had to excuse him. And then you find out that consistently he held on to the law being repealed, the Terrorism Prevention Act of 2013 having been repealed by the 2022 Act, and that he can no longer be tried. But I really don't know who told him all of that or who tutored him, because if you look at Section 4 of the Evidence Act, it talks about savings in repealed law. Even Section 97 of the said repealed law, if you look at Section 98 actually repeals the Terrorism Prevention Act 2022, repeal the 2013 law, and then Section 97 saved whatever actions, whatever acts, and proceedings that have been initiated pursuant to the previous law. So every lawyer knows that for every law that is repealed, there is what they call the saving clause. So I wonder who tutored him and who told him, to keep hammering on the case that the fact that the law had been repealed, and then use that to spoil his own case. Even as a lawyer that is standing trial, it is always advisable to employ the services of another lawyer to guide you, because it's usually very difficult for you to be in the dock and at the same time defending yourself.
All right,
except when you are charged for contempt in the face of the court. But in this case, despite having the services of very senior lawyers, the defendant still decided, to sack his lawyers and defend himself. And at the end of the day, the way he conducted the matter, I knew that certainly we will get here.
Let's bring in Mr. Jawondo. Given Mr. Kanu's repeated filings and requests to file final addresses, how would you say the court balanced his, procedural rights against the need for them to actually maintain order and deliver justice in court today?
Well, I think the court did the right thing. You see, the issue of filing of addresses is regulated by the Agile and the practice directions. Having been given enough time to file his address, and having failed to utilize that opportunity, it is not the business of the court to force him to file an address. Neither will the court continue to wait for him. More so that he did not even file an application for extension of time to file his address. So the court was right in holding that in any event, somebody who did not give evidence would have written an address on himself, having disengaged his lawyers. Well, as a person, he has that right. But having been given the right and having failed to utilize that right, the court was right. So there was nothing procedurally wrong in his not filing an address, because it was his right of election that he exercised not to file an address. So the judge was very, very on a very good ground by going ahead to deliver judgment. In any event, addresses are meant to assist the court. They do not decide the outcome of the case. What parties do at address stage is to highlight the relevant fact and apply and cite or make available to the court relevant decided cases and statutes to assist the court in arriving at a just decision. So if a party decides not to write or to submit address, that does not mean the court will not consider the case on its merit. And I think that's what the court has done in this case. Consider the case on the merit based on the evidence available to the court. And you discover in the course of the judgment, not much reliance was placed on the address of the prosecution, rather on the fact as presented. And that is the most important aspect in coming to a decision in a case.
All right, Mr. Jawondo, we do need to take a break now. When we return from this break, we'll continue even as we analyze this judgment delivered earlier today by Justice James Omotosho in the case involving leader of the proscribed indigenous people of Biafra, Nnamdi.
Alleged against him are capital in that each of them carry their sentence. In that case, the conditions for bail are very onerous and rarely met by a defendant applicant. That's number one. So, two, the case having been tried to the conclusion and judgment reserved, the issue of bail cannot arise again at that stage. Because if the application is to consider, the judge will rule on it. Is it not even better for the judge to go ahead and deliver judgment one way or the other? So that if, like, it's now conflicted, he can go to court of appeal and ask for bail pending appeal. But at the time he asked for bail, that was most unauspicious time, having regard to the stage of the proceedings. So for me, the issue of bail raised by him, the issue of ruling of superior courts, like was arguing the Supreme Court was wrong to have remitted the case back for trial, the Court of Appeal decision having been overruled by the Supreme Court. The only applicable and relevant decision is that of the Supreme Court. So it can no longer rely on the Court of Appeal decision.
All right, Mr. Jawondo.
Overruled by the Supreme Court.
Okay, so let's put this in perspective and help us to understand. I think this question would now go to Mr. Oshoma. How exactly do Nigerian courts typically differentiate between bail pending trial and bail pending appeal? And why was Mr. Kanu's case considered outside these categories?
Yeah, certainly when you are filing a bail application, what we all know, once a defendant is charged, and there are certain grounds for granting bail, whether it's a capital, the punishment for that offense carries, capital punishment, or is a misdemeanor. So, but in this case, that's why I said earlier that there is need to have a lawyer do the job of a lawyer. So when you file a mere bail application, one, it is not a bail pending trial. You are not asking the court, permit me to go home, pending when you are trying my case. Also, judgment had not been delivered. It's when judgment is delivered and you're on appeal and you have been convicted, you can now say, well, since I'm challenging my conviction, please grant me bail, pending when you will hear this appeal. The court said that is, his application did not fall on either of those cases. And then secondly, there were 3 applications that he filed. One was, like I said, consistently hinging it on that the law has been repealed. The law has been repealed and that there is no law, forgetting that every repealed law has saving sections. And then also that, and the bail was also, the grounds for the bail was that haven't been charged on a repeal law, and then he should be asked to go home. So, and you now begin to ask yourself, you have not proven to the court in your address that you have been charged on a repeal law, and then you have not shown sufficient ground that the law had been repealed. Mind you, you have filed an application previously for a no-case submission, and you were overruled. And then the third application was a time for that he has not waived his right to filing a final written address. And we all know by the rules of court practice direction that every procedure by the court is not open-ended. There is time for doing everything. And that is why the judge ruled that you have a right to fair hearing. But that your right to fair hearing is not open-ended. It is limited. For example, if procedurally, if a defendant, for example, file a final written address, the claimant has 21 days within which to file a reply. In Abuja, for example, and then to file a reply, and why the defendant will have 7 days to file a reply on point of law. So if a final written address is served on you, and you decide not to file your reply within that time, or you are the claimant after the close of pleadings and then you have, a time within which to file your final written address, the court can't wait for you endlessly.
All right,
so, you are the defendant. So this is what has played out in this case. Because a non-lawyer decides to play the job of a lawyer or to conduct the job of a lawyer. And that's one thing that is very fatal to the defense.
So both you, Mr. Shoma and Mr. Jawando, do agree that, Mr. Kanu's decision to sack his lawyer did actually have an impact on how this turned out. But then let's talk about how this judgment, let's talk about how it reconciles the tension between claims of self-determination under the African Charter and Nigerian constitutional law. Mr. Jawando, please.
Has nothing to do with the issue of self-determination. It is true that there is a right of self-determination under the international law, but that right must be exercised in accordance with the law and not in a way that amount to terrorism, not in a way that amount to unlawful killing and assassination of citizens. And that is exactly what Mr. Kanu did in this case. Yes, you have a right to agitate for self-determination, but not in such a way that will now become a treason or treasonable felony like he did. So the right that he claimed to be exercising is a right, but exercise of that right is a different thing. How and manner the right is exercised depends on the way and manner you carried out the activities and whether that will infringe on the law or not. And in this case, the way and manner Kanu exercise or purportedly exercise the right to self-determination is against even the international law. So it is a case of relying on an existing right, but not following the due process in exercising that right.
I hear you, Mr. Jawando.
So once you run foul of the law in the exercise of that right, the fact that the right is there does not mean you cannot be disciplined or called to query by the way and manner you purportedly exercise the legal right.
All right. Now, let me pose this to Mr. Oshoma. We're at a time when Nigeria is being faced with terrorism challenges and a recent sentencing of an IPOB leader to 20 years in prison. How will this Nnamdi Kanu's judgment affect Nigeria's fight against terrorism, radicalization, and the enforcement of the Terrorism Prevention Act?
It's quite unfortunate that we are very sentimental when it comes to trials of this nature. Also, permit me to say, because government also has not shown fairness and the same zeal in fighting terrorism in the northern part of the country. I am happy that recently 2 terrorists were arrested up north and their trial will begin soon at the Federal High Court here in Abuja. And if government consistently shows the same zeal across board and the amnesty is not extended to certain persons, while some persons' trial will see the entire hog, then people will not be sentimental. I don't think people will now be calling for the release of Nnamdi Kanu. Any which way, Nnamdi Kanu also has not shown remorse to show that truly he's remorseful for the actions or the allegations that were levied against him until the judgment today. So in the same vein, I think that the only way we can truly fight this kind of menace headlong, terrorism, banditry, is for government to be fair and hard across board. There should be no half measures. There should be no soft landing for some persons, while there should be mortar and pestle and pounding in some other areas. So these things will certainly, breed sentiment. Some persons will say, why don't you let this person go since you are letting others go? And no nation can truly thrive when you have this kind of character. And quickly, permit me, on the issue of self-determination, you have a right. We say, ubi juicy being remedium. Where there's a right, there's a remedy. But where your right stops, that's where mine begins. You have a right to self-determination. Right. And like my learned colleague has said, there are procedures for achieving this right. You cannot compel people to follow your procedure and then threaten them with death and expect that government will just fold its hands.
All right, Mr. Shoma, let's get final thoughts now from Mr. Jawando as to wrap up the conversation. In just about 30 seconds, please.
Well, I think the judgment is today is a watershed. And like my friend said, the battle against terrorism should be wholesale And in fact, if you ask me, the battle against terrorism should not be limited to arresting, try. In fact, what the government is doing today, the government is advised, that is neutralizing. Because these people don't believe in any human right. Is to emphasize neutralizing, and those who are arrested, let them be prosecuted and dealt with expeditiously.
All right, gentlemen. Former Attorney General and Commissioner for Justice in Kwara State, Salman Jawondo, SAN, and Liberals Showman, experienced lawyer, thank you very much for your time on the program today.
Thank you, sir.
Well, that's a program, everyone. Watch a repeat broadcast at midnight and at 6 a.m. I am Abbas Sedi at the New Adremi. Bye for now.